we'll jump quickly to the next course for today. That's criminal litigation. And already we have our facilitator. She's been here with us since, in fact, for like over 20 minutes. She's been here with us. So I will grant this floor to Mary. You can take the floor now, Mary. Thank you.
Thank you, Barcewa. But I believe that everybody can hear me. I want to see how we can be done with trial 2 today. So I think for 2 weeks now, I've been taking trial 1. I took some questions last week. I also asked that if there were further questions, you could just send me a direct message on WhatsApp. I didn't get any, so I just hope that good from there. So today we're taking trial 2, which is the preparation and evidence. If you were in the first criminal litigation class when I took trial 1, we were contemplating at some point if this evidence part comes before trial 1, but apparently it is after trial 1. So today we're going to be dealing with the burden of proof. This simply means that the person who has the burden to establish the existence of a set of facts, that's what like burden of proof means. And in criminal litigation, the burden of proof is on the prosecution to prove all the ingredients of the offense. This is already explanatory, I guess, because it's simply saying who the burden of proof is on. If you are the one bringing up a matter in criminal litigation, you are the one, you that's the prosecution who's bringing up a case, you're the one who the burden of proof rests on. I hope you understand that. So you're the one bringing up this issue. You are the one who has the burden to prove that the defendant is guilty of what you have said that he or she is. Then where are the exceptions when the burden of proof may be on the defendant? Please, if you are going through your material and you see places where they write things like when the burden of proof is on the accused, I already explained in the earlier classes that we no longer use accused, we now use defendants. So take note of this, especially during your exams. Exceptions when the burden of proof may be on the defendant. Cases where the knowledge of whatever had happened is peculiar to his knowing, like where the facts are peculiar to the knowledge of the defendant, then the burden of proof will now be on the defendant and not the prosecution. Defense of insanity. I mentioned last week when we're talking about cases of insanity where trial can go on and then while investigation on whether the defendant is actually insane, when cases like that come up. So in defense of intoxication and insanity, the burden of proof may be on the defendant. Remember, I also told us about general rule here last week. I mentioned that in
Mary, I think your network is breaking.
you find things like when they say the burden of, oh my god, I'm so sorry, please. Please just give me a minute. Is it possible? Can you hear me now?
Mary, I think I can hear you.
I think my network is really. Let me try to change my location, please. So can you guys hear me now? I'm really sorry. Hello? Yes, we can hear you. Okay. Sorry about that, please. So I was explaining general rules and exceptions. I was saying that last week I took out time to say that, especially in terms of like your exams, when you are talking about general rule, do not base it off, like don't just write the general rule. Ensure that you take notes even in scenarios when given. I mentioned that a general rule is that the burden of proof is usually on the prosecution, but there are exceptions which I have mentioned. What's the standard of proof in criminal matters? This means that the essence to which a burden of proof should be discharged. So in criminal trials, the standard of proof is that it is proven beyond reasonable doubt. That's the standard of proof in criminal matters. Therefore, once there's any doubt on the case of the prosecution, it will be resolved in favor of the defendant. You get? So the prosecution who is bringing the matter must be able to prove beyond reasonable doubts. Now we're moving to competence of witnesses in criminal trials. The general rule is that all persons are competent to testify except that they are one, prevented from understanding the questions put to them, two, prevented from giving rational answer by reason of extreme old age, tender years, disease, whether of the body or mind, or any curse of the same kind. You understand, right? Now you see that there's another general rule here that says that all persons are competent. We mentioned this last week. That all persons are competent except that one, they are prevented from understanding the questions put to them. They cannot understand the questions that's put to them, or because of ill health, extreme old age, disease, whether of the body or of the mind. A person of unsound mind may testify during lucid intervals. I mentioned also last week that if you are going through this particular part of your criminal litigation, ensure that you are using either an e-copy or a physical copy of your Evidence Act. You would really, really need it because there are so many references to the Evidence Act. I believe that in evidence law or even the Evidence Act, you can already tell what lucid intervals for people who have an unsound mind. That's the period where they are able to, like, they come back to their senses. It is said that they have lucid intervals where they can tell they are just that period. So in that period, the person of an unsound mind can actually testify. Also, a dumb person can testify by sign or in writing made in open court. Who is a co-accused? Okay, sorry. A co-accused is a competent witness too for the defense, but not a competent witness for the prosecution. I hope we got that one. Hope it did not confuse you. A co-accused is a competent witness for the defense, but not a competent witness for the prosecution, except he has been tried separately, he has been convicted and sentenced or discharged on a no prosecute. Believe you already know that, you must have done that topic, or pleaded guilty and convicted. A defendant may, while testifying on his own behalf, incriminate his co-defendant. Such incriminating evidence may be utilized by the court to convict either or both of them. Now, still on who can be a witness, who can be a competent witness. We're moving to the evidence of a child. A child of less than 14 years can give unsworn evidence. Please, emphasis on unsworn evidence in court. However, the court must satisfy that the child understands the question put to him, one, and can give rational answer to it, two, and the child knows the duty of telling the truth. Three, there was a past question like this where they asked, at what point can the courts take the witness, the unsworn evidence of a child? The answer to it is, are these three things that I listed. Are one, that the child understands the question that was put to him, that child can give rational answer to that question, and that the child knows the duty of telling the truth. Please and please, as I'm speaking to you now, I can literally just picture past questions and even our own questions during our bar finals. Criminal litigation might look really, really easy, but if you miss something out of it, you have scattered the entire point. And sure, I would also advise that when you're taking things like this, don't start from the child knows the duty of telling the truth. Learn it from that the child understands the question put to him, that the child can give rational answer to those questions, and that the child knows the duty of telling the truth. Don't start from down or middle. Start from the way it is. This is in this is also in the Evidence Act, Section 209, Sub 1 of the Evidence Act. Note that the court, however, cannot convict a defendant based on the unsworn evidence of the child alone without corroboration. I believe we all know this. Now, a child of 14 years and above can give sworn evidence, which will need no corroboration, but the court will caution itself if it decides to convict on it. Constantly see general rules. I mentioned earlier that a child can give unsworn evidence in court. Now that's like the general rule. They are now saying that a child of 14 years and above can give the a child can give evidence in court, but it must be sworn. Or a child that is less than 14 years, a child of less than 14 years can give unsworn evidence in court. That's the first one I said. Now I'm saying that a child of 14 years and above, so from 13, 12 down, would have to give unsworn evidence, and that the court cannot convict on just that unsworn evidence without any form of corroboration. However, a child of 14 years and above can give sworn evidence, which we now need no corroboration. You must also add that the court will caution itself if it decides to convict on that evidence of the child that's 14 years and above. Now we're going to be talking about compellable witness, that's the compellability of witnesses. This is the process of bringing an unwilling witness to court to either testify or tender documents, or even both. It is only competent witness that can be compelled. I have talked about competent witnesses already. That's this one that I just finished from. Now I'm talking about compellable witness. They are saying that when you hear the word compellable, like to compel, it literally means to force somebody. You get? So we are saying that when it comes to compellable witness, the only group of people that can be compelled to come and be witnesses in court are people that are competent to give that witness. I'm saying this because you can find scenarios where they will put it. Don't be in a haste, just go and say, oh, you know what, they can now compel the person. The first thing attribute you want to check is that person. They might put a scenario like the person is extremely sick or has disease of the body and mind. Then you just be so fast to say, oh, the person can be compelled. That person cannot be compelled because they are not competent. So it is only competent witnesses that can be compelled. Persons like president and vice governor and his deputy, diplomats, judges, etc. cannot become compelled, even though they are competent. Modes of compelling witnesses. We did this last week. I'm just going to run through. There are generally three methods of securing attendance of witness in court: through witness summons, through the subpoena. There's subpoena deus tecum, that's for tendering documents, and the subpoena ad testificandum. I'm not sure I'm pronouncing it well, but this is for oral testimony. Number of witnesses. In criminal trials, there are usually no required number of witnesses for the prosecution to call to prove a case, unless where the offense requires corroboration. Therefore, the evidence of one witness, which is credible and cogent, would prove the most hideous crime. So there's no specific number. They're saying that you can even decide that you just need one witness. However, in cases of probation, you can now say, okay, this is the number of witnesses that you would need. But there's no specific number. Note, however, that the prosecution must not call any number of witnesses. It is advisable for him to call eyewitnesses. This is because where there are eyewitnesses and he fails to call him or her, the court may reasonably infer that if the eyewitness had been called, his testimony would have been favorable to the defendant's person. I believe that this one is explanatory, but just in case it isn't, it's saying that the prosecution does not have the right to particularly call out any witness. However, if there's the eyewitness, there's somebody that was there when it happened. If there's somebody like that there, the prosecution is expected to call that person out. And if it is found out later that there was an eyewitness and prosecution did not call, the court will just say, oh, okay, if there's an eyewitness, somebody that saw this incident happen, and you didn't call out this person, that means there's probably something you are hiding, or there's something that the eyewitness can say that to be in favor of the defendant. Corroboration. Sorry, please, just give me a moment. So corroboration means producing more than one source of evidence in proof of a case. In all the situations where the law of evidence requires corroboration, the prosecution will require the testimony of at least two witnesses to secure a conviction. The circumstances are as follows. Before I continue, you see that I had mentioned earlier that in criminal trials, there's no specific number of witnesses. However, you hear me mentioning that at least two witnesses. This is because it is corroboration. You already know what corroboration means now. I give a testimony, you need somebody's own to like be in sync with what I've said. So in that case, you now understand what we are saying, at least two witnesses, because I cannot give a testimony in court and still corroborate my own story again. I need somebody else. So the circumstances are as follows: testimony of an accomplice. I think I want to pause at this point to know if people understand. I'm just yapping. Please let me know if you can hear me, if I'm too fast, or if you're not understanding, if there's something I need to explain further.
Temitayo, are you here?
Yes,
Do you understand what she's explaining? Or she's been explaining?
yes, I am.
Okay. Temitayo, how about you? Huh? I'm not sure
I'll just
Temitayo is here.
continue.
Okay.
Since Onye said she's understanding, I'll just continue. So I said the circumstances are as follows. I'm going to take it again. Corroboration means producing more than one source of evidence in proof of a case. In all the situations where law of evidence requires corroboration, the prosecution would require the testimony of at least two witnesses to secure a conviction. The circumstances are as follows: testimony of an accomplice, that's somebody that partook in what had happened, the unsworn testimony of children, the testimony of a tainted witness, treason and treasonable felony. unless the treason alleged is the killing of the president or an attempt to endanger his life or injure his person. Offense of sedition. So we're going to move to oath and affirmation. Generally, before a witness testifies, you must either be sworn on oath or affirmation. However, as an exception, a witness may not testify on oath where the witness is not a believer in any of the non-religions or is a person whose religion forbids oath taking, or the witness is a child less than 14 years. Mentioned this one already. Note that before a witness starts testifying, the registrar orders all other witnesses in the case to go out of court and out of hearing. However, this does not apply to the parties themselves or their respective counsel, even if they will be called as witnesses. Where a witness remains in the court, it will not affect his competence to testify. Therefore, his evidence will be admitted, but less weight will be attached to it. This is also a very popular question. If you have started going through past questions, you must have seen something like this. So, where a witness, you've seen like the rule now that when a witness is the first witness is like called upon to take his oath and all of that, that the other witnesses are supposed to leave the courtroom. But however, where the witness refuses to leave, or maybe for whatever reason is present when the other person is taking his oath, he said that it's not as if that person's evidence will just be quashed like that. They're only saying that little weight will be attached to it. Examination of witnesses. This one comes every time. Like I feel like it's even like a compulsory question. This is a process of eliciting evidence from a witness. It involves 3 stages, which are examination in chief, cross-examination, and re-examination. So, like I said, when you see a listing like this, especially in criminal litigation, please don't start from cross-examination first. Take it one after the other. Examination in chief, cross-examination, and then the re-examination. Examination in chief is the examination of a witness by the party who called him. Explanatory, yeah? The main purpose of examination in chief is to obtain from the witness all the facts in support of the case of the party calling him. It is aimed at strengthening the case of the party calling the witness. What all this one is saying is that the person that called the witness, examination in chief is just a way to, like, let's say we have a case now in court and I came with my witness. I will call my witness and then we start examination in chief. And I just want my witness to state the obvious, more like to strengthen the case, to just give an intro, like deep insight, and bring out the case in a better light. That's literally what examination in chief is. Like I said, this is a question that comes out every year. When they ask you to list, sometimes they'll tell you list and then explain. Take out your time. Don't just write the examination in chief is when the party is examination of a witness by the party that calls him. You can add sections. There's a section 214 sub 1 of the Evidence Act here. Then you talk about the main purpose of, like, why do they do examination in chief. Just like a side note, in examination in chief, the best questioning pattern to use is open questions. Now, what are open questions? Open questions are questions that give the witness the liberty to tell the story from his or her personal experience and knowledge. It is preferred in examination in chief because it makes the testimony of the witness more coherent and believable. It usually starts with words like what, why, how, explain, where. So you know what I said earlier now, that examination in chief is just like you are the one that brought the witness. So you want the court to know more into the case without you even saying so much. So you begin to do examination in chief. Open questions are used in examination in chief because it just helps the person explain. It gives the, when you say what happened on this day, you're not tying the question to just one thing. The person now begins to explain and explain and explain. Before you know, they've explained literally everything in the case. So yes, that's what examination in chief is. Counsel should be cautious in using open questions in examination in chief. Therefore, he should guide the witness to avoid telling stories that are not relevant to his case or that are not favorable to his case. Because it's an open question, you see, you find that some people just ask, and when you ask now, the witness just starts to say a lot. Like I said, it's an avenue for them to explain. So sometimes they might explain things that are not relevant or things that are not favorable, things that they're not supposed to say in court. So it's expected that the counsel guides the witness beforehand. Um, if you have been in court a couple of times, when you see some lawyers and their witnesses, you can tell that beforehand the witnesses were properly briefed before they came to court. Leading questions. Leading question is any question suggesting the answer which the person putting the question wishes or expects to receive. Generally, leading question is not allowed in examination in chief unless in any of the following exceptions. This is something that always comes out in exams. Introductory matters that are not in issue, like your name, your address, your occupation. Then matters which in the opinion of the court have already been sufficiently proven before the court. Then if the court on its own allowed it, or if an objection is not raised to a leading question and same is answered by the witness. So I already stated that leading questions they're generally not allowed in examination in chief, because leading questions are like you're asking a question that the person has no other option than to give you the answer. Like you're asking a very straightforward question. So when you ask questions like that, you're already suggesting the answer to the person. I'm trying to find the sufficient example now. Like maybe when you say, instead of saying maybe what happened on this day, you now say, so on this day, did you perceive, okay, instead of saying what happened at the accident scene, for instance, you now say things like, so when you went to the accident scene, did you see this person with a knife? Now you have, number one, you have already established through your question that they went to the accident scene. You have also established that there was somebody with a knife. When in actual sense, the witness is supposed to be the one to narrate and even get to the point of whether there was a knife or not. So you have suggested the answer to the person, and this automatically comes up as a leading question. There are, however, cases where a leading question is not an issue. Cases like introductory matters, like you're saying, okay, so what is your name? Or you are Mr. Ajayi, right? Something like that. So that's like a leading question, but it is acceptable because it is like an introductory matters to this person's name. I said matters which, in the opinion of the court, have already been sufficiently proven if the court allows it, and if the leading question was asked and there was no objection. Sometimes the defense counsel, once the prosecution counsel has has asked a leading question, you see that the prosecution counsel will raise an objection to it. So if they did not raise an objection, it was answered. It to be allowed. Cross-examination. The examination of a witness by a party other than the party that called him is called cross-examination. It comes after the examination in chief has been completed. Cross-examination is not mandatory. If the counsel on the opposing side has no real issues to prove by the questions, then it should refrain from asking them. Note, however, that where more than one defendant is charged at the same time, each defendant will be allowed to cross-examine a witness called by the prosecution before the witness is re-examined. Also, a co-defendant is allowed to cross-examine the witness brought by another defendant. Sorry, I'm pausing because here it just keeps saying accused, and I don't want to use the word accused anymore. This must be done before cross-examination by the prosecution. This particular thing I just said, the question has been showing up since 2017 up to 2020, and I think it was also in our own exam too, which was like 2020, 2023 or 2024, thereabouts. Failure to cross-examine a witness on a vital point he raised during examination in chief may be regarded as an admission of such issue. Remember that I said that as a counsel, you don't need to, cross-examination is not compulsory. You don't have to. There's no need to, because instead of wasting the time of the court, you don't have to bring up another question. However, if there was like a serious issue that you did not tackle, kindly note that it will be admitted that it will be taken that you admitted to whatever it is. Maybe the witness mentioned something that was very crucial and there was no cross examination. Counsel did not take on cross examination. The court will just assume that you admitted to what that witness had said. What is the purpose of cross examination? This was a valid question in 2024, a composite question. What was the what's the purpose of cross-examination? The purpose of cross-examination is to contradict, to destroy, and to discredit the evidence of a witness. Remember, don't forget the purpose of examination in chief. To discover who the witness is and his pursuits in life. So impeach the credit of the witness and make his testimony fertile. To weaken or qualify the case of the opponent. It is used as a means of establishing the party's case through the opponent's witnesses. If you go through it, it's literally just saying that you want to discredit what the other person has said. You just want to destroy the examination, what that other person has said. You want to destroy. That's usually like the purpose of cross-examination. If you've been in real court issue, you would see that cross-examination is always very the tension is always very high, because what the counsel that's doing the cross-examination wants to do, he just wants to scatter what has been laid before. If you say when you went to the accident scene that you saw some people with knife and there wasn't an accident, you begin to hear the counsel bringing up different things. So cross-examination is usually always to just destroy the evidence that has been laid before. In cross-examination, leading and close questions are to be used. It is not totally advisable to use open question. This is because the use of open question in cross-examination may give the witness an opportunity to fill the loopholes or errors committed during examination. So I told you that in examination in chief, open questions are advised to be used, and then leading questions in some cases. In cross-examination, however, leading questions and closed questions are to be used. When you give the witness an opportunity to use, when you use open questions on the witness, you give them an opportunity to just say anything that they forgot to say during the first time. Limitations in cross-examination. In cross-examination, only relevant questions are allowed. Such questions need not come from the issues raised during examination in chief. Therefore, it is wrong to state that in cross-examination, the sky is limit. The limit of cross-examination is relevance. So, usually in cross-examination, it is expected that you ask. That's why they advise that sometimes if there's no need, after examination in chief, cross-examination is not compulsory. You don't have to. You don't have to, because if you carry on cross-examination and you don't have any relevant thing or you don't have anything to say, it's just as simple as you wasting the time of the court. Everything that you need to, because some people say that in cross-examination the sky is the limit. Something like a scenario to just point that, okay, you can ask as many questions or you can bring as many scenarios. Relevance is the key. If the question is not relevant, it should not be asked. The following questions cannot be asked in cross-examination. Questions that are improper or too remote, indecent, questions that are indecent or scandalous, questions that intend to insult or annoy or needlessly offensive, the court may not allow it. It is not advisable to ask a question that you do not know the answer to in cross-examination. This is because such question may be detrimental to your own case. I hope you are still here. Re-examination. This is the last stage of examination of a witness. It takes place where necessary after cross-examination. It is conducted by the party who called the witness. Please ensure that you know who is taking cross-examination, who is taking re-examination, who is taking examination in chief. Know the person that called. If you know these things, I explained in our very first lecture, I said when you are attempting questions, or even when you're going to sit for your bar finals, take classes like this really seriously, because what it does to you is you might not get a full understanding of it now, but there's no way they'll be taking this topic in class and you will not remember that, oh, we treated something like this here. So when you gather the knowledge from here, the one in class, the one you would eventually read, you have sufficient knowledge enough to be able to explain a topic on its own. And that's what will help you. Doing copy and paste method might not entirely be good for you, because sometimes you never understand. When you have sufficient knowledge of the topic, you know the general rule, you know the exceptions, you know a case to add up on it, and you are good to go. So, leading questions shall not be asked in re-examination. New matter is also no new matter is entertained in re-examination unless with the leave of court. Re-examination is just like, you are how do I put it now? You are recalling everything. You can even say it could be like a summary, like, okay, we have done examination in chief, we have done cross examination. We are just doing it again. So it cannot be bringing up a new matter at the stage of re-examination, unless, however, with the leave of court. Refreshing of memory. Where a witness finds it difficult to remember an event which had taken place a long time ago, such witness is permitted to refer to any documents made by him at the time of the transaction or so soon afterwards. This is explanatory. The witness may also refer to any writing made by any other person and read by him, and if he knew it to be correct. An expert may refresh his memory by reference to professional treatises. The procedure for refreshing of memory is that counsel must seek leave of court for the witness to refresh his or her memory. Any writing which the witness intends to refresh his memory shall be produced and shown to the adverse party, if he requires it, and such party may, if he pleases, cross-examine the witness upon the writing. I hope we understand this refreshing of memory. Hostile witness. This is something that comes up every year, to the best of my knowledge. A hostile witness is one who, in the opinion of the court, is biased against the party who calls him, is unwilling to testify, or who supports the other party. The general rule is that a person calling a witness is not allowed to discredit him. However, when the witness testifies against the party who called him and is unwilling to tell the truth and is evasive in the answers he gives, he will be termed a hostile witness. I am the prosecution. I am the one that brought you as my witness. We're all good. We're all cool. You have been briefed. Then we come to court, and all of a sudden you start saying something totally different. You start giving answers that are not appropriate. You now go against me and try to start testifying against me that brought you to court. You start trying to discredit me. You'll be termed a hostile witness. What's the procedure? The party calling the witness will have to apply to the court to declare the witness hostile. The effect of the court declaring a witness hostile is as follows. He can be cross-examined. He can be asked leading questions. He can be discredited using previous inconsistent statements made by him. Both his previous and present statements will be disregarded by the courts. You are the one that said you were there when the thing happened. All of a sudden, we are now in court. You say you're not there again, but you had said that you were there before. So the person who brought you as a witness to court will now have to apply to court to we now have to apply to court to declare you a hostile witness. And when the court goes through everything, first you be cross-examined, you be asked leading questions. The inconsistencies with the things that you have said, you say you were there, now you say you're no longer there, will make your evidence become disregarded by the courts. Moving forward, power of the court to put witness to put questions to witness. Okay. The court has the power to put questions to any witness before it. The aim is to clear up ambiguities or a point left obscure in his testimony for the determination of the case justly. However, the court is not to descend into the arena or ask damaging questions to the witnesses or an accused or a defendant. So the court has power to ask to put questions to any witness. Maybe there's a place that's not clear. There's something that you said that they do not really understand. Something that still has a lot of comma, or maybe a lot of inconsistencies. The court can put up that question to you, and you as a witness, you have to respond. However, the court does not have the right to put up any damaging questions or questions that just suggest things that you have not said, or the court does not really have the right to imply things that you have not mentioned, or things that are not particularly maybe relevant to the case. The power of the court to call or recall a witness. The court has powers to call any witness, whether or not such a witness has been called by either party. This power extends to recalling a witness after the close of the defense on matters unforeseen which arose during the case for the defendant. For the defense, it's still same thing what I said. The court has the power to call or recall a witness. They have power to ask witness questions. But like I mentioned, the court cannot go into areas that were not dived into. They cannot just descend on you and bring up a topic that you did not say, or begin to imply things like, what's the perfect example now? Maybe you were supposed to say something and you didn't say it. The court cannot begin to put words into your mouth, something like that. A party to proceedings may have a crucial need to recall a witness for further examination. He shall apply to the court and support his application with facts as to why and what he intends to put to the witness. Self-explanatory, yeah? A party to the proceedings may decide that, okay, there's like an important need for us to call this witness and ask questions or maybe get something. He cannot just go right into it after this thing is being done. He would have to apply to the courts and even support his application with facts as to why he intends to bring in the witness again. Admissibility of documentary evidence in criminal trials. The basis for the admissibility of any document tendered is if it is relevant to the facts in issue or facts relevant to the facts in issue. Tendering of documentary evidence. Generally, the content of a document can only be proven by tendering the document itself in evidence. The content of the document itself must emanate from the personal knowledge of the maker. Also, the person who made the document must be called to tender the document, unless the maker is dead, is unfit to testify by reason of mental health or old age, is outside Nigeria, and getting him will be unreasonable or cause delay if the maker of the document cannot be found. I mentioned 4, that the maker is dead, that is unfit by reason of his mental health or old age, is outside Nigeria, and getting him will be unreasonable or cause delay if the maker of the documents cannot be found. There was a question I saw. That question was like from like a past question I was going through one time in law school, and they wrote something like the person was not in Nigeria, but he was going to come back the next day, something like that. You know what they were trying to do there? Because they say he's outside Nigeria. Most people will forget the facts where they wrote, and getting him will be unreasonable or cause delay. He's outside Nigeria is not a valid excuse for the document to not be tendered by the person who made it. It is only it's only an excuse when getting that person will be unreasonable, or getting that person will cause delay. So if the person is coming in the next day and getting them is not unreasonable, coming in is not unreasonable, and it's not going to cause any form of delay, then that person should come around to tender the documents themselves. In tendering a document, it is the original copy that will be admissible. Where the original of a private document cannot be found, the photocopy may be tendered by laying proper foundation to show the whereabouts of the original, either that the original is lost, cannot be found, or that it is in possession of the adverse party. If it is a public document where the original is not available, it is only the certified true copy, that's the CTC, duly certified by the appropriate authority in accordance with Section 104 of the Evidence Act, that will be admissible in evidence. Please know the difference between the public and the private documents. Know the difference. It's in private document that you can easily just tender the photocopy by laying foundations of the whereabouts of the original. Like maybe the original was caught up in fire, maybe it was destroyed, something like that. However, if it's a public document, it's only the certified true copy that can be, where the original of a public document, is not available. It's only the certified true copy that can be tendered. Note that once a document is admitted, oral evidence can no longer be allowed in proof of its content, because the content of a document speaks for itself. We all know this. How to lay proper foundation. This question is a composite question in all the past questions I've seen, down to even when I wrote bar finals. Ask the witness for the following questions for original documents. Do you have the document in court? If you see the document, can you recognize and identify it? How will you identify the documents? Usually in practice, the counsel will now seek the leave of court at this point to show the documents to the witness for identification. Then you now proceed and say, is this the document? Then he'll face the court and say, my lord, I apply to tender the document in evidence. So, like I mentioned to you, this is something that you have to sit with your own notes and go through. Like maybe me saying it like this now, you might not absolutely understand, but yes, this is how it happens. And like I mentioned earlier, when you're stating things like this, do not start. You see how the question is like in sequence. Do not start from, if you see the document, can you recognize it? The first thing is, do you have the document in court? So that's how you begin. If it is if it's for photocopy for private documents, or certified true documents for public documents, it is a different thing. So please note, this one I just mentioned, how to lay the foundation, is for the original document. If it's a photocopy for private document, or a CTC for public document, it is, do you have the original of the document in court? Sure, you can see different. Do you have the original? Where is the original? Which copy do you have? If you photocopy, if you have the photocopy of the CTC, if you see the photocopy of the CTC, can you recognize it? How will you identify it? You see the progression now. In this other one, you're saying, do you have documents in court? Because of course, it's the original that is there. That's for the original. When it's a photocopy, you want to know where is the original? What happened to the original? That's when you start hearing explanations like, oh, the original got caught up in fire, or it got destroyed, or this or this. Computer generated evidence. The necessary condition precedent must be laid by the person intending to tender the evidence for it to be admissible. This is also a question that comes up in composite questions literally almost every year. The condition includes that the computer was regularly used to process or store the type of information or evidence sought to be tendered. Sorry, I'm pausing. This stuff is just bringing memories from what had happened. I just thought to put in more emphasis that this is always like a compulsory question that comes up. Your lecturers will tell you when they begin to take this topic. Make sure that you take out time, please. Make sure you take out time to go through this again. One, that the computer was regularly used to process or store the type of information or evidence sought to be tendered. Two, that the evidence was supplied to the computer in the ordinary course of business. Three, that the computer was functioning properly, and if it did not affect the processing and the production of the document or evidence. This is very important. Then four, an oral testimony or document by the person who operated the computer testifying to the above facts as 1 to 3. Expert evidence. The general rule is that the opinion of an individual is inadmissible in evidence. However, the opinion of an expert may be admissible by the court. An expert is any person that's specially skilled and knowledgeable in certain areas. The expert must possess the skill and qualification to be so referred. The court can reject expert evidence if it does not conform to common knowledge. Note that for the expert evidence to be admissible, proper foundation must be laid to show the expert's qualifications, skills, and years of experience. Exam focus, that's hearsay evidence now. The testimony of a witness must come from his or personal knowledge, from him or his personal knowledge, experience, or I'll take this again. Testimony of a witness must come from him, his personal knowledge, experience, or belief. Hearsay evidence is therefore any statement, oral or written, made otherwise than by a witness in a proceeding or which is tendered in evidence. Generally, hearsay evidence is not admissible. However, there are exceptions to the rule against hearsay evidence. But okay, I'm going to just explain what this one means. You already know when I say something is hearsay, it means that I heard it from somebody. It is not directly my statement. And they are trying to say that the testimony of a witness originally would just have to come from him, his experience, as in cases of like expert witness, like his experience, his expertise, or his belief following the course of his duties. But they're saying in here, hearsay evidence is usually like something like a third-hand statement or second-hand statement, rather, something that you heard from somewhere. Examples of these hearsay evidence are dying declarations, documentary evidence, affidavits. They're saying that the general rule now is that hearsay evidence is not admissible. But in cases like this, that's like in dying declarations, documentary evidence, that they can be admissible. Visit to the locus in quo, that's the scene of the offense. If court is satisfied that there is need to inspect the venue of the crime, or where the evidence is to be inspected but cannot be conveniently brought to the court for proper determination of the case, then the court will conduct a visit to the venue. It may be conducted on the application of the parties or the courts. The courts can decide on their own, or the parties will apply that there should be locus in quo, and it can be made any time before judgment. Procedure for the conduct of visit to locus in quo. There are two ways. The court may adjourn to the locus in quo and continue trial there by taking witnesses in evidence, and later the court will convene in the regular court to continue the trial without recalling the witness. Or the court will adjourn to visit the locus in quo, take note of the things observed, and reconvene in court to continue proceeding, where it will take the testimony of witnesses in court. All the defendants must be present at the venue during the visit to the locus. This is to give them the opportunity to clarify uncertainties and contradictions. However, failure to take the accused person, that's defendant now, to the venue will not vitiate the trial. Are we together? I think that pretty much we have been able to do justice. We've been able to do justice to this topic. And I actually enjoyed this topic. Oh, I don't know if it's just me. It was straight to the point. If you have any questions, I still have some time here, so you can let me know. You can bring up something that you did not understand, or something you want us to talk about. Maybe you want me to buttress on. You can let me know, please. Is there something you do understand?
Temitayo Oyeye, do you have any questions? Temitayo Oyeye, are you here? Are you with us? Can you hear us?
I don't have any question for now.
Okay.
Temtayo, you say you don't have any question for now. I would like to know, is that you actually understand everything, or you don't understand, so you don't even know where to ask questions from? I'd like to know what your feedback is like. For now, I still want to go over it and read it again and then. But for now, what you explained, I was able to understand them well. Then when I go over it and then, because I know that there are still going to be some parts that I'll read and then maybe I might not understand it fully, then I'll probably reach out for to understand. Okay, thank you. Thank you very much for the class. Thank you. You're welcome, Timothy. Onye, how about you? I'm not sure Onye is still on this call.
Yeah, I'm not so sure either. But thank you very much, Mary, for this class. I think it's very engaging because even in practice you can see most of these things you explained even today play out, and then it educates lawyers on when to raise objections instead of just sitting there in court and allowing the other parties to just flaunt this procedure. So I believe that even for most of us here, that mess Onye and things that I'm talking about, that on extension, these are practical areas that you should also avail your minds to, so that when you read, you remember what Mary has taught here today, and to and to help direct you in your classes, in your reading, I mean. So thank you very much, Mary. Do you have any other words for us before we end your session?
Okay, I would say that. Oh, let me just. If you can help me with your mic. Okay, thank you. So I'll just say that, yeah, if you notice, when I was taking today's class, I made sure to talk about areas that they repeat every time. Someone told me when I was in law school that law school is not hard. but that is, I think he said something like he's overrated. But if you decide to now say, oh, he's overrated, and you just leave it there, you would definitely fail. So these are the minor things. Like you notice that they repeat questions. They repeat questions a lot. Law school will always repeat questions. All the questions they've asked so far, no matter how they try to coin it, I think what they do is they just change their strategies. So if you can go back and read this thing again, it's self-explanatory, it's straight to the point. Check out for the places. You see some materials, they'll take out time to show you all the years that that particular question has come out. Try to read materials like that too, so that you're well informed. Also go through past questions. I'll just basically give you the same advice that my seniors gave to me when I was in law school. It's literally almost like the same thing, and I honestly cannot wait to see you guys at the bar. I think that's it. That's it pretty much. I'm taking criminal litigation. The other people are taking different topics. Ensure that you don't miss out. This time you're not wasting it. The time you dedicate to come and hear other people talk about something and they're not speaking to you like your lecturers, they are not just saying it and leaving it there. They are taking out time to also explain, hear your questions, and all of that. Please don't take it for granted. You can also encourage your colleagues to join this. A better way you can do it is you can maybe speak to your roommates. Then once it's time like this, you could just put one phone and all of you are listening, you are writing, you're jotting down things. You can even be going through the materials we're teaching at the same time so that you can get better understanding of it. So that's it pretty much. Thank you, Bastayawa.
Thank you very much, Mary. Thank you so much for this evening. I hope you enjoyed the rest of your weekend. Thank you very much. So this brings us to the final session for the night. In fact, I mean, Miriam has been here quite in and out of the session. Yes. So she'll be taking us on a very core topic for civil litigation. It's fundamental human rights. And just as a brief intro, Miriam is also an alumni. In fact, I think in an inaugural set for OSMG. Yes, that's also to add. Mary is also part of that set. So you can imagine that they've been here before and they are giving back to all of you. So you are not, like Mary just said, you're not in the wrong place. So without wasting much time, yes, I'll just yield the floor to Miriam to take her session. Thank you very much.